Again, I want to welcome everybody. My name is Noah Hodgetts. I'm a principal planner in the Office of Planning and Development at the Department of Business and Economic Affairs, BEA. And with me today is Ben Frost, Deputy Executive Director and Chief Legal Officer at New Hampshire Housing, as well as Alvina Snegich, Assistant Planner here at OPD, who is going to be helping to manage the chat, put links in, and also deal with any technical problems folks might be having. Ben and I are going to take questions at the end of this webinar. You can either utilize the chat function to ask your question, or you can raise your hand during the Q&A portion of the webinar, and Alvina will keep track of your questions. So the agenda for today, first, Ben and I are going to review the significant planning and zoning statutory changes enacted in 2023 during the 2023 legislative session. We'll talk about a few other planning and zoning statutory changes that happened in prior legislative sessions. And then we'll do a high-level preview of 2024 planning, zoning, land use, and housing bills. And finally, as I said, we'll wrap it up with some time for questions and answers at the end. We do have a hard stop at 1 o'clock, though. With that, I will turn it over to Ben.
Thanks a lot, Noah. It's great to be with you all, and I know we have a lot of people who have signed up for this. Looking forward to a really exciting 2024 session with the legislature and kind of a wrap-up of what happened in 2023. And I want to start talking about the 2023 session. And this slide says planning and zoning statutory changes, but actually the first I want to talk about is not a planning and zoning bill per se, but really one that deals with agriculture and a municipality's ability to adopt bylaws regulating agriculture, in particular noise. Farms can be messy operations and they can be noisy operations. Consider the sound of cows lowing in the field at maybe 2 a.m. disturbing the neighbors, or in an orchard where they turn on the fans to keep the frost from settling and killing the buds on apple trees. They can be noisy. Municipalities, and this is a bill that addresses RSA 3139, which is towns' ability to adopt bylaws. This limits what a municipality, a town, can do with regard to noise regulation on agricultural operations, and says basically you can't adopt quiet hours ordinances that limit agricultural operations. Note that this does not apply to agritourism, which is a separate issue. So you still have the ability to regulate, say, noisy weddings at farms. So that is still open for regulation. Note also this now law went into effect in August, is limited in its application by its terms to towns. That said, there is a different statute, RSA 4717, which deals with cities and their ability to adopt bylaws. That law confers upon cities all of the powers that towns have to adopt bylaws. And I think it's a reasonable inference that the limitation here on towns' abilities also would apply to cities, but it's not perfectly clear. So be aware of this and the limitations that you have. This doesn't mean, however, that a planning board doesn't have some power. So consider planning board doing site plan review on an agritourism operation. Yes, you can still regulate hours of operation, noise levels at the boundaries of the property. You still have that authority. I want to move on now to one that is really truly planning and zoning, and this deals with a planning board's approvals of subdivisions and the surety, that is the financial protection that a planning board might seek of the town's interests regarding improvements in a subdivision. And this is found in the Subdivision Enabling Statute, RSA 674-36. And this legislation spells out with some specificity how planning boards are to deal with releases of those sureties as the improvements are made. So it calls for phasing of the security says when substantial improvements are made. Now, what is a substantial improvement? There's some room for debate there. That's really best ironed out as a condition of approval. There's also a statutory figure. You can do an annual cost escalation. And this has been increased from a maximum of 10% to now 15%, but it is limited. So you can't do a cost escalation factor on engineering, administration, and other non-construction issues. But for construction, yes, you can do a cost escalator now of up to 15% annually. Post final approval, you have the ability to do financial surety, but it is now expressly permitted for, and I always thought you could do this anyway, but expressly permitted for landscaping and final pavement. I can't imagine the dispute that went on that created that compelled the legislature to adopt this, but for some reason there must have been in some municipality a dispute over whether you could bond for final pavement. Well, of course you can, and now it is expressed in the statute. There's also a new section in this statute, Roman numeral 4, that deals with the form of surety. And it says you can't require it to be a letter of credit, only a letter of credit or cash or a passbook. And to younger members attending here, a passbook is something that old folks like me used to use when we go to the bank. We would present our passbook, which showed how much money we had in our account. You can't require that to be posted. I'm not sure anyone actually uses passbooks anymore. And here, the last thing here, this is really a surprising change in the law, and this came about as a result of negotiations between the House and the Senate in a committee of conference because they had differences on the bill. It says that the planning board shall allow road and utility construction to begin without a bond. This is a change to the law, a substantive change. But you can require a bond for improvements to be, and you must require it to be in place prior to the sale of any lot or building permit issuance for a structure for human occupation. There is some debate right now, and Noah and I have been part of that, I'd say a healthy discussion on whether this applies retrospectively to older approvals of subdivisions. So the question came up, we have some old approvals that may be 10, 15, 20, 50, 75 years old, possibly, and whether this limitation on planning board authority applies to those. And the consensus view among us who have been talking about this is that yes, it probably does, meaning that even if there is a condition of approval that requires posting of a bond before beginning construction, this new law may supersede that. But that's just our debate and our consensus view of that. Here, planning boards, before you act on this, do consult with your own legal counsel. And there's more to this law. It gives a process for release of bonds and based on inspections. So it gives you a timeline, which is now statutory. So pay attention to this. And also it identifies how communications are to occur between the developer and the town. So a request for a release has to be made by hand delivery, presentation in hand to a town employee, or by courier, or by service. The word service, I believe, includes the United States Postal Service. But phone calls, no, because there's no documentation of that. Email, I think probably not. I think you can make an argument that email is effective, but I'd be concerned about that being subject to dispute. This legislation also eliminates what I call the well-intentioned but confusing conditional language for optional sprinklers and whether you're doing a cistern. That is all gone. And so the question then remains, what if a fire chief wants to have some sort of fire protection? Generally speaking, the fire chief can make that requirement, but there is confusion here now. So that is in effect. That went into effect in October. So just here's the practice point: review your processes and make sure that you're complying with these new statutory requirements, especially the timing of releases of surety and the type of surety that you're requiring. Also, this is a separate bill. This is not planning and zoning so much as it is driveway permits, but recognize that under state law, it's the planning board that has the authority to issue driveway permits on local roads, typically delegated to the road agent or to the DPW director, the Department of Public Works in your municipality. And that's okay. You can delegate that power. But there are some limitations here. And this law deals with sometimes conflicts between driveway permit and what the state fire code calls for. And what this law says is that the state fire code will not supersede local land use board authority over driveways. And that's the planning board, really. No one else has the authority unless it's delegated by the planning board to the DPW director. But then there's really confusing language here: when not governed by RSA 236.13 for 1 and 2 family dwellings. Well, that is the statute that gives the planning board the power to do this. What are the circumstances when planning board's authority over driveways wouldn't be governed by that statute? That's where it's confusing. So I'll get to that confusion in a moment, but this does require driveways over 150 feet long to be 12 feet wide. I actually went out and measured my driveway, and fortunately I am compliant with that at about 14 or 16 feet, depending on where you are. But even though the planning board sort of reigns supreme here, the planning board really should consider, it says shall consider, the fire chief's recommendations on width, vertical clearance, et cetera, et cetera. That doesn't mean it's binding, but you shall consider it, give it due consideration, if you will, when you're doing something, say, a subdivision. And this really gets to the confusion or the ambiguity here. What does it mean? Well, consider a planning board looking at a 3-lot subdivision with a common driveway. A condition of approval could be specifications on the construction of that driveway outside of the right-of-way. So we're not governed by RSA 236.13 outside of the right-of-way. So that's a good example of where it's not governed by that statute, but is within the planning board's authority. So the planning board does have jurisdiction here. But remember, you shall consider the fire chief's recommendations, but those recommendations are advisory. So my recommendation is listen to your fire chief always, but use your own judgment too. I'll turn it over to Noah.
Great, thank you so much, Ben. So next we're going to talk about the Housing Champions Designation and Grant Program. I think in statute it says singular program. I have put the S on the end as it's actually multiple programs. So what does the Housing Champions Program do? In short, RSA 12-0:71 through 76, so it's 5 separate chapters, creates a designation program which includes 5 different buckets of qualifications. The first is adoption of land use regulations that promote workforce housing and other types of housing necessary for the economic development of the state. Training of land use board members, planning and zoning board members, as well as implementation of water and sewer infrastructure and implementation of walkability measures or public transportation improvements or sidewalks. So if a community meets all 4 of these, those first buckets qualifications, they would then be eligible for Housing Champion designation. There's a 5th, the statute also outlines a 5th optional tool of adoption of financial tools that incentivize the development of workforce housing as well. But the statute is very clear that one is optional, and the first 3 are essentially requirements. In this all components of the Housing Champions program, just taking a step back, were included in Senate Bill 145 from last year, and we'll talk a little bit about the history of the bill and the long, kind of going back 4 or 5 years of trying to get this to the finish line. And this was eventually tabled by the Senate and included in the in House Bill 2, the budget trailer bill, which was obviously passed. So that is now law. In essence, once a community has achieved Housing Champion designation, that designation will be good for 3 years. And then as a result of that designation, a community and municipality will have preferential access to discretionary state infrastructure funding. What's different, that discretionary state infrastructure funding programs will be really broken into 3 different pots. There'll be actual infrastructure funding, so infrastructure funding to support infrastructure to help develop additional workforce housing and as the statute says, other types of housing necessary for the economic development of the state. Could be water and sewer. I think the statute names water and sewer, telecommunications infrastructure, energy infrastructure, so on and so forth. The other 2 grant programs that the Housing Champions program creates is a per unit incentive program for the development of workforce housing, somewhat similar to the Invest New Hampshire municipal per unit grant program, except that, and we won't go into the finer details, this is for, I believe, the previous fiscal year, and this is based on the definition of workforce housing. So 60% of AMI for 3-person rental households and 100% of AMI for 4-person ownership households. The final grant fund that the Housing Champions, or that the language in House Bill 2 for Housing Champions created was the creation of a municipal planning and zoning regulation grant program, somewhat similar to the Invest New Hampshire Planning and Zoning Grant Program and the Housing Opportunity Planning Grants that some of the participants on today's call may currently be working on, with the one caveat that part of the mission of that program is to help support communities that may be thinking about applying for Housing Champion designation, but not be ready yet to actually apply because they don't feel like they're going to necessarily meet all 4 necessary qualifications. So originally, Senate Bill 145 had proposed $29 million for those 3 different funds. The compromise language, or the language that got included in House Bill 2, also included a reduction in the funding down to $5 million. So for FY 24 and 25, so that as of this past July through June 30th, 2025, the Housing Champion program there's $5 million for all 3 of the grant programs I just mentioned. And BEA, my agency, is currently in the process of drafting initial rules, and then has to go through an initial per statute, an initial program advisory committee, and then we'll go through the formal joint legislative committee on administrative rules rulemaking process, with statute stating that the rules need to be adopted no later than July 1st, 2024. So another land use related bill from last session was the land use review docket, which was originally, like Housing Champions, was a standalone bill and then got consolidated into House Bill 2. So it was originally House Bill 147. The land use review docket establishes a subject-specific docket to hear appeals of all local land use appeals, so not just appeals related to housing or residential uses, but any land use appeal, commercial, industrial, anything being appealed in any land use statutes, so 674 to 676, 677. This would be essentially not creating any new jurisdiction, but just kind of assigning a specific judge of the Superior Court to just deal with land use appeals. And it wouldn't have any effect on the concurrent jurisdiction of the Housing Appeals Board. However, in terms of timing, there is a couple tweaks there for appeals. So the House Bill 2, or language adopted in House Bill 2, stipulates that the structuring conference has to be held within 30 days. The appeal is filed. And then there's a deadline established for delivery of the certified record. And then the hearing on the merits by the land use review Superior Court Justice with both parties has to be held within 60 days of receipt of the certified record. And a decision is to be issued on the merits within 60 days of that hearing. As I mentioned, the language in House Bill 2 also establishes a new judge position to administer the land use review docket. That judge, the executive council, recently confirmed former Housing Appeals Board member and actually former OPD staff member, attorney Michael Klass, as the first justice for the land use review docket. And actually just last week, the judicial branch issued the formal order establishing this docket, and we expect it'll begin hearing cases in early 2024 with the goal of trying to handle land use appeals through the Superior Court process quicker than they would be if they were just kind of gone into the pile of all the other cases that Superior Court would typically hear. So a few bills before we turn to 2020, before we turn to some other recent statutory changes, a few bills that didn't make the cut last year was House Bill 44, the fourplex bill. We'll get to that. That's being reincarnated, reintroduced this session in a different form. We'll talk about that in a few minutes. House Bill 423, expanding requirements for accessory dwelling units, ADUs, also being reintroduced in a somewhat different form this in the 2024 session. And finally, Senate Bill 224, enabling mandatory inclusionary zoning, which was sent to interim study by the Senate earlier this fall. That will also be introduced in a somewhat different form, as we'll talk about in a few minutes in the 2024 session. So with that, we're going to go back to a few very quick pre-2023 statutory changes. So just a little bit of history here, going back a little bit. As some of you may recall, way back in 2019, pre-COVID, seems like a lifetime ago, Governor Sununu convened a housing task force, of which actually Ben and I were both members of. And that task force established an array of legislative recommendations, municipal incentives, including at that time thinking about revenue sharing to incentivize and aid the production of workforce housing, as well as thinking about what other obligations need to be kind of created to increase housing production, specifically workforce housing production. That led to the introduction of House Bill 1629 and 1632 in 2020. Of course, that session, as I said, was curtailed pretty early on due to COVID, and so those bills got stopped in their tracks. Then in 2021, those two bills were essentially combined into House Bill 586. That bill, for different reasons, did not make it out of the House. And then, so finally in 2022, there was a third bite at the apple. House Bill 586 became Senate Bill 400. And again, it got hung up in the House. So what ended up happening as a result is it got many of the components of Senate Bill 400 got included as part of a compromise bill, House Bill 1661. In legislative parlance, kind of became known as the Christmas tree bill or the parking garage bill because there was appropriation for the legislative parking garage. But much also in kind of that compromise, much also got left on the cutting room floor, especially in comparison with the 2020 bill as originally introduced, including what got cut out or left out was the New Hampshire Housing Champions designation program. And as I just mentioned, finally last year, as we just talked about, a separate bill through House Bill 2 to the budget policy trailer bill we did finally pass that. So in essence, short of a couple of little things, 4 years later, all the legislative priorities, major legislative priorities that were in the Governor's Housing Task Force have now been adopted. So with that framework in mind, I just want to go back very, very quickly and I'm sure folks have seen this, say, why are we going over this again? Partially because a lot of the deadlines are now in effect, and I just want to make sure people haven't forgotten about this. So first of all, House Bill 1661 stated that my office, the Office of Planning and Development, was going to develop voluntary tests based on our standard self-training models for both planning and zoning board members. You could find those on our website on the planning and zoning training page. Elvina already put the link in the chat. The next item, RSA 673:16, Roman numeral 3, established that local land use boards must publish all their fees in a single location accessible to the public, and failure to post those fees prior to a particular application will result in their waiver for that application. And then this is the most recent change that just went into effect. RSA 674:17, Roman numeral 4 states that as of July 1st, 2023, any elderly housing incentives, age-restricted incentives, incentives for housing for older persons, as the statute technically defines it, shall be deemed applicable to workforce housing developments. So that means that if you have an age-restricted housing overlay or an age-restricted zoning district, where age-restricted housing is allowed and you have incentives for age-restricted housing, they now carry for workforce housing if you did not pass any changes at town meeting, or your board, if you're not a town, or your town council or city council has not made any changes to the zoning ordinance to either do away with your age restricted overlay or make any tweaks. RSA 676:3, Roman numeral 1, states that findings of fact are required to support all local land use board decisions, both approvals and denials. RSA 674:33, Roman numeral 8, states that there's now, for the first time, a clock on how long a ZBA, a zoning board of adjustment, has to issue decisions of 90 days after receipt of the application. And then just a couple more here. RSA 676:4, Roman numeral 1, subsection C1, clarifies that the planning board has 65 days to act on an application after acceptance of the application. And it also eliminates that 90-day extension that used to be there. The planning board could basically appeal for that extension. It does away with that extension unless the applicant and the board mutually agree to extend the 65-day timeline. And sorry, I didn't mention this previously, but when you download the slides, each of these sections of RSA, and when we'll get to the later bill titles, are all hyperlinked. Hopefully I did them all quickly. If there's a couple errors, my apologies, but they should take you to the actual statutes themselves if you want to actually read the finer language yourself. So a couple more changes here. RSA 677:20 requires Superior Court may require a bond to be posted by a person challenging a land use board decision. Attorney fees and costs may be awarded then if the court determines either party acted in bad faith or with malice. It's a pretty high bar. I am not an attorney, but that is a pretty high legal precedent. And finally, there were some tweaks to RSA 162K, the tax increment financing TIF district statute. Specifically, it states that or enables the use of TIF districts for the development of housing, typically to support infrastructure development. And it also expands the definition of public use in RSA 162K to include acquisition of real property for development of workforce housing, while prohibiting the use of eminent domain for this purpose. Finally, for additional information about House Bill 1661, enacted during the 2022 session, refer you back to the joint NHMA OPD BEA joint memo, changes to planning and zoning laws in 2022, a guide for municipalities, which Attorney Nate Craze from New Hampshire Municipal Association and myself authored, as well as the August 10th, 2022 webinar, which we conducted on the subject. Again, there's a link to that in these slides. So the final bill we're going to talk about, or I'm sorry, two more bills, and we'll get into the 2024 bills. So RSA 674/76, created back in 2022, created this carve out for primarily religious uses of land and structure. Specifically, RSA 674:76 states, no zoning ordinance or site plan review regulation shall prohibit, regulate, or restrict the use of land or structures primarily used for religious purposes. Provided, however, that such land or structures may be subject to objective and definite regulations concerning the height of structures, yard sizes, lot area setbacks, open space, and building coverage requirements. So essentially, as long as said requirements are applicable, regardless of the religious or non-religious nature of the use of property, and do not substantially burden religious exercise, those can still be in there. But it's still a very, very kind of blanket a new exemption for primary religious uses outside of zoning. So with that in mind, what you do at the first inkling of an application for religious use or structure, talk to your attorney included, and then before conducting any non-binding pre-application processes. And that goes as far as even preliminary conceptual consultation or design review, just to make sure that the attorney's aware that you've gotten an application for something that might have religious use, as well as there's an affidavit to basically say, for an applicant to say this is religious use or not. That's contained again in the joint guidance document that OPD and NHMA that we issued back in 2022. I just want to note on this real quick that just in the last month, at least to my knowledge, OPD's knowledge, the first case of was decided, at least in the papers. The Hanover Planning Board acknowledged that RSA 674:76 severely limited their review of a site plan application for Christ Redeemer Church in Hanover, which interestingly had been under consideration by the Planning Board and ZBA since at least 2016, and was just the subject of a case which went all the way to the state Supreme Court earlier this year. And so with this law now, that permitting of that project is moving, but for this law, it may not have moved ahead. So with that, I'm going to turn it back to Ben.
Thanks, Noah. We're going to go back a few more years to 2018, actually, and this is a slide I've been using for the past 5 years, really as a reminder to folks that there is an upcoming date-based event happening. July 1st, 2024, a provision of law goes into effect that will prohibit the introduction to the market of new residential units created in pre-1978 structures. 1978 was the year in which lead was banned from paint, and I think we universally acknowledge that lead paint poisoning is a scourge on the health of our children. For children up to age 6, it causes permanent neurological damage, and so therefore naturally is also a hazard to pregnant mothers. So these are really important laws. This standard, though, was adopted by the legislature in 2018. Again, prohibits the introduction to the market of new residential units in pre-78 structures without a lead-safe certification. And that means you have to have someone who is trained and certified to issue these certifications. It can't be just by any contractor who saying, "Oh, looks good to me." No, that's not good enough. How will this happen? Well, the law is silent on that. I believe it's going to fall primarily to the responsibility of local building inspectors, because the introduction to the market of new residential units presupposes the issuance of a certificate of occupancy pursuant to a building permit. Because to create a new unit, you're going to need a building permit, and you're going to need a CO. Before you get that CO, that unit has to be certified as lead safe. That doesn't mean that the lead has to be removed. It means it has to be pass requirements, standards saying that it is safe for occupancy. This is a really important law, and people are just now beginning to pay attention to it, even though it was adopted in 2018. Now we're going to move ahead to 2024, and we're going to go through this fairly quickly. Noah and I have a bunch of slides with a lot of different bills. It's going to be a very active session in the legislature. And I want to start with bills dealing with planning board and zoning board procedures. And I'll just touch upon each of these bills. There'll be opportunity next month when Noah does another webinar to talk in more depth about these upcoming pieces of legislation. But starting with CACR, that's Constitutional Amendment Concurrent Resolution, CACR. That's how we amend the New Hampshire Constitution. CACR 16 relates to local governance. And it's a curious piece of legislation because it would require, if this is adopted by the legislature, and constitutional amendments do not go to the governor, they go straight to the voters after the legislature by supermajority in both chambers passes them. And then the voters would have to pass it by supermajority. If this were to go into effect, it would require, among other things, financial statements on any variance or waiver granted by a planning board, variance by a ZBA, changes to zoning would have to go. So imagine this, a ZBA grants a variance, that then has to go to the voters of the town. This is what this legislation would require and must be approved by a 3/5 supermajority of the qualified voters at any municipal meeting. So you would have to annually vote on all planning board waivers of subdivision or site plan regulations or ZBA grants of variance. So it's an interesting piece of legislation, and we'll see what the legislature does with it. Next in line is I think a helpful piece of legislation that allows the ZBA to notice hearings on the town's website. After that is relative to the quasi-judicial authority of planning boards. And this is another fairly complex piece of legislation that adds to RSA 673(2), which is the kind of where we get what is a planning board all about. And it adds to that some things that seem pretty common sense, like how you consider facts, but also includes the swearing in of witnesses. Now recognize the ZBA currently has the statutory authority to swear in witnesses. The planning board does not. This would extend that to planning boards, but also talks a lot about how to draw conclusions from facts presented to you. It is worth taking a look at. I can't really say what the legislature will do with that legislation, though. House Bill 1297 is similar in some regards to CACR 16 in that it looks at the kind of rights-based ordinances. And this legislation would limit how zoning ordinances can be built and limit it to things that deal with public health, safety, and welfare. Now that is certainly part of the zoning enabling statute, public health, safety, and welfare. But over time, we've seen the purposes of zoning grow substantially with support from decisions by the New Hampshire Supreme Court. House Bill 1359 is a piece of legislation that we are very excited about, and this was an idea of our friend and colleague at the Municipal Association, Nate Grays, and this would serve to limit who has the ability to appeal a decision, who has standing to appeal. Right now, any party who is aggrieved has the ability to appeal a decision of a planning board or a ZBA. And how do you become aggrieved? Well, you show up at a hearing and you complain. There's your grievance. You're stating your beef with something. That gives you standing because you showed up and complained. Well, this bill would pull us back to older law, which limits who has standing to appeal, and it would limit it to abutters, a little more broadly defined than the current statute says. And it would also address a curious decision of the New Hampshire Supreme Court. It's Seabrook One Stop, I think, versus the town of Seabrook, in which the Supreme Court said, well, we looked at the definition of statutory definition of a butter, and a property that is located diagonally across the street is not an abutter. Only those directly across the street are abutters. And even though you can argue that the two properties are touching on a point because they're diagonally across, the Supreme Court said no. This says, well, yes, actually, it would constitute an abutter. Following that, House Bill 1461, this would require all properly noticed meetings, planning board, ZBA, and others, to be live streamed. And I'm sure that the Municipal Association has some things to say about what the potential costs are of that. And finally, Senate Bill 533, relating to quorum and how you establish a quorum at a public meeting. Last year, the legislature adopted a change to how statewide boards can constitute quorums. And that means you only have to have a third of the members physically present. The remainder of the quorum can join remotely. And this essentially is taking that path. Now move on to let's see, I'm having difficulty advancing. Right. There we go, back up now. Here, okay. At the beginning of this calendar year, 2023, the Speaker of the House, at the request of the House Democratic leader, established a special House committee on housing, along with some other special House committees as well, dealing with other issues. The Speaker appointed 10 members to this committee, evenly split between Republicans and Democrats, chaired by Goffstown's Joe Alexander. And this committee has worked really tirelessly over many months to receive testimony, and then starting in the summertime, developing legislation that its members are introducing in 2024. And here you see some bills that the Special House Committee will be hearing. They'll actually continue, and they will conduct the public hearings on these bills. So starting with House Bill 1065, this is actually a placeholder bill, but it would require it would allow the conversion of existing structures to 3 or 4 residences. So three or 4 units, apartments in a building, and would not require them to be sprinklered. Right now, the State Fire Code requires that those conversions have sprinkler systems in them. The State Fire Marshal has concluded that that is, in fact, unnecessary. It does not promote public safety. But as long as those units, those 3 or 4 units in the structure, have independent means of egress and a rescue window, then public safety will be ensured. I say it's a placeholder because there is another bill that will seek to amend the fire code, and it looks like that will be the vehicle for this. But the special committee wanted to make sure that this would move forward. The next bill that the Special House Committee on Housing will hear deals with the subdivision regulations and completion of improvements. This is dealing with RSA 674-39, which is the so-called 5-year exemption. And it actually completely rewrites that statute and says basically any final approval by a planning board shall be immune from future changes to zoning or subdivision regulations or site plan regulations, regardless of the passage of time. This legislation also extends that to changes to the building code and to the fire code. So RSA 155A and 153 respectively. There are some concerns. These have been expressed by the State Fire Marshal and by the Building Officials Association that it would be difficult for local building inspectors and local fire chiefs to have on hand the old codes going back many years. But that is the legislation that has been put forward. Next is a bill, House Bill 1361, dealing with regulation of manufactured housing and manufactured housing parks and manufactured housing subdivisions. The objective here is to make it a little easier to develop manufactured housing in municipalities. This legislation has language that is introduced, but it is likely to be changed at the public hearing when that happens, sometime probably in January. Next here is a bill 1399 to essentially require municipalities to allow 2 units in a dwelling. So we'll call it a duplex bill. And then finally, House Bill 1400 regarding maximum number of parking spaces. I have difficulty reading this bill because I think the way it's written is not what it was actually intended to do. It affects, it's regarding the maximum number of parking spaces required, but I think that the sponsor was looking to limit the, restrict the minimum number required. So we'll see.
And before you move on, I think
yes.
you skipped House Bill 1291, the ADU bill.
Oh, so I did. Thanks, Noah. So House Bill 1291 it modifies the existing accessory dwelling unit law. And that was adopted by the legislature in 2016. You can find it in RSA 674, 71 through 73. And that requires every municipality to allow at least 1 attached ADU. Detached at your discretion. This legislation would require municipalities to allow up to 2 ADUs, one of which could be detached. If there are 2 ADUs on a property, then the municipality would also have the power to require that one of them meet workforce housing standards of affordability and income targeting. So this also pulls back on some of the discretion that municipalities have, say, with regard to parking standards, for example, that exist in the current law. So this is an important bill to pay attention to. Now, moving on to, and this is the last slide I'll have before turning it back to Noah. Other housing-related bills, there are 3 bills that should make it easier to develop septic systems. These are being done in cooperation with the Department of Environmental Services, which I think is really important. And these 3 bills come out of the Special House Committee as well, but they're not going to be heard by that committee. House Bill 1053 requires municipalities to allow residential uses in commercial zones. And it's pretty flexible in its requirement, but that's basically what it's calling for. House Bill 1202, we talked about driveways a little earlier with regard to the recent change in law. This is really directed at the Department of Transportation and its authority to issue driveway permits on state highways. And what this does is it establishes time limits for DOT action. For residential projects, 30 days to grant a permit. For commercial or industrial projects, 45 days to grant a permit. After which, if DOT has taken no action, it is deemed granted as submitted. This is probably going to result in DOT either denying lots of them within those 30 or 45-day limits, or seeking an extension of time from the applicant, which is part of the bill as well. Let's see. I'm going to skip over a couple things. I would say House Bill 1483 would require planning boards to do a water study for subdivisions to show the adequacy of water supply. House Bill 1602 would expand the jurisdiction of the Housing Appeals Board to include decisions of state agencies. So consider DES with alteration of terrain or dredge and fill permits that would go for housing and housing development would go to the Housing Appeals Board potentially, or to Superior Court. Continuing on with the Housing Appeals Board theme, another bill to combine the Housing Appeals Board with the Board of Tax and Land Appeals, which is kind of a peer entity at the state level. And then finally, we have 2 bills here. Senate Bill 224, which was retained by the Senate in committee and would expand the options under the housing opportunity zones in RSA 79E and would give municipalities the authority to adopt mandatory inclusionary zoning. That was retained. Following on that is a partly similar piece of legislation that will be introduced in January, Senate Bill 538, called the Home Omnibus Bill. That is an omnibus bill dealing with homes or housing. that has a lot of different provisions in it. Among them, a requirement for municipalities to accept alternative parking arrangements, so off-site parking, requiring municipalities to allow in a portion of their jurisdiction soil-based lot sizing that is based on the science and a property's ability to address septic effluent while also preserving water quality. And a variety of other provisions, including a revamped and I think substantially improved provision for allowing municipalities to have mandatory inclusionary zoning. And now I want to turn it back to Noah to talk about the rest of the bills we have here.
Great. Thank you so much, Ben. And I'm going to go through this very quickly, knowing that we only have 10 minutes left, and there is a couple questions in the chat. So House Bill 1314, and forgive me for looking away as I go through these sections. I have the text of each of these bills up on my other screen. So House Bill 1314, relative to Comprehensive State Development Plan. This is a state development plan, which my office, OPD, is charged with developing, but has not been actually formally published or created and adopted with approval by the governor's office since the year 2000. This would make some tweaks to what sections of what sections are included in the comprehensive development plan, including adding a new environmental threat section to deal with things like biological contamination, waste disposal, so on and so forth, as well as clarifying that the natural resources section should include topics including drinking water, aquifer identification, protection of our lakes, rivers, estuaries, wetlands, shoreland, uplands, so on and so forth. And then House Bill 1371 modifies the master plan statute, 672, 1. And the 17 or so, this would add an additional optional chapter that municipalities can add to adopt as part of their master plan to include a chapter on waste reduction. Notably, as you've probably heard me say in the past, municipalities are already kind of adopting a lot of other kind of master plan topics, not necessarily kind of articulated in statute. So I'm not, unclear how much that bill will actually do. House Bill 1052, now we're into kind of miscellaneous bills, would require that when an applicant is submitting their excavation and dredging permit to DES for in a wetland, that they also have to submit both a paper and a digital copy. House Bill 1121 creates an exemption towards for filling in certain small areas of wetlands, after a natural disaster or flooding event. There's a note that I skipped 1281. Okay, we'll come back to that in a second. House Bill 1196 is relative to requests for easements for the purposes of laying sidewalks along class 1 through 4 highways. So not, and that basically says DOT has to, if a municipality wants to put in a sidewalk next to the road, they have to allow that easement. There's a little bit of unclarity of who's actually funding that. DOT, I know, said in their fiscal note that would onus to go back to DOT potentially, but the cost of that is indeterminate. House Bill 1281, thank you now, was about relative to rental restrictions, and it does two things. Zoning restrictions on residential rental property. So A, that says that a municipality may not limit persons per bedroom to less than 2 persons per bedroom. And it also prohibits the municipality from enacting or enforcing any ordinances which limit any restrictions in rental property based on any familial relationship. So that was 1281. Going back to this list here, House Bill 1208. I don't have let me just pull the language up here. Has to do with timber harvesters notifying that they are going to be operating in a wetland, I believe. Do I have this language up right now? Before they start cutting. House Bill 1221 clarifies that a solid waste landfall should be considered a facility or public facility for purpose of a determination that a project is a DRI or Development of Regional Impact. House Bill 1234 relative to Class 6 roads not maintained by a municipality says that unless there's an agreement in place to not cover the costs, where is it? There must be kind of some agreement for coverage of costs for maintenance of roads on Class 6 roads. And I believe this is a follow-up to the one of the bills last year, which I think went to interim study. That's House Bill 1234. House Bill 1268, relative prohibiting the issuance of large groundwater withdrawal permits for the commercial use and sale of bottled or bulk water, places limitation on the how much groundwater from bulk uses can be extracted from the ground. 57,600 gallons of water in any 24-hour period. And finally here, House Bill 1320, which says that upon the transfer of real property, a buyer must be notified of the flood risk, and basically is the property in a FEMA designated flood hazard area or not. And it also charged my office with providing a viewer so that a buyer can see where that area is located. Our office already does have a New Hampshire flood hazard viewer, but it would require some modifications to that. 4 more bills, and then we'll leave a few minutes for Q&A. House Bill 1567 modifies, this bill would be going to the child care statute. I'm sorry, the House Special Committee on Child Care, is my understanding, both modifies the purpose of zoning ordinances to say that child care is an express purpose, but that also that home-based child care, which meet the definition of DHHS's licensing requirements, should be exempt from local zoning. And Ben, correct if I'm wrong on any of this. And it also basically says, again, makes changes in 674 to actually clarify that home-based daycares, child cares that are conform to DHHS child care licensing requirements are exempt from zoning. House Bill 1635 is a lot about cleaning up and making more conformance between housing standards, usually administered by the health officer or the code enforcement officer, and a definition of short-term rentals to short-term rentals being for less than 30 consecutive days, as well as modification to the term definition of short-term rental in the meals and room statute, and the definite, and also clarifies that tenant protections in 78 and 540C do not extend to non-recreational, do not extend to short-term rentals. But am I explaining that right? In short, I got that more or less right? Okay,
Yeah, I think
great.
so.
Okay, 1641 says that large parking lots with, I want to say, don't quote me on this, more than, 50 spaces. No, it's bigger than that. Basically, parking lots above a certain size have to have a solar arrays on top. You have to look back at the exact number. I'm sorry, I don't have that on me. Senate Bill 160 clarifies that expansions of agritourism are not above a certain size. I think it's, and again, I'm trying to get all the bills here going back and forth, are not privy to the exemption in 674-32A. And then finally, Senate Bill 390 relative to the defining critical habitat. So with that, That was a lot of bills to go through, and we're at 12:59. Ben, I know you have to hop off in a minute. I just want
I
to say
can stay a few minutes, Noah.
Okay, great. Very, very quickly. Here's a bunch of the links, as I said earlier. Alvina, if you can put the link to the slides again in the chat so that people can actually, everything here is hyperlinked to include all the different training resources covered today as well. And I also want to say we're going to be issuing an updated version of our OPD's Planning Board and Zoning Board handbooks early next year in 2024, which will incorporate all the 2023 statutory changes we covered today. I've also included a link to New Hampshire Municipal Association's free Fast Democracy Bill Tracker, specifically their planning, zoning, land use section, which includes something like, I think, 72 bills, and you can subscribe to that list, and you can get either weekly or daily automatic emails, which will tell you whenever there's a status change committee, when the public hearing gets scheduled for that bill, when the committee's taken an action on any bill, when there's been a vote, so on and so forth. That's free. Anybody can subscribe to that list. Finally, as Ben alluded to earlier, for a deeper dive into a good bunch of the bills that we just went over very, very quickly, planning, zoning, land use, housing bills, we're going to be conducting January's planning lunches at noon plan webinar on Thursday, January 18th from 12 to 1:30. I've made that an hour and a half to go in to talk about more of these bills in detail. And the link to that is here. And Alvina, if you can also put that link in the chat now too, that would be very helpful. Now, for a few minutes, Ben and I will be happy to take any questions. I think we have a couple questions in the chat earlier, so we're going to go back
right
to
now.
that.
I see Michael's question regarding the parity between workforce housing and elderly housing in RSA 67417 Roman numeral 4. And I think this is an excellent question, and I don't really have a clear answer to this because the law does not address it head on. So, Michael, I think the best answer is that it is going to be it's going to require a reading of each individual zoning ordinance and talk to your town's legal counsel. Because what if you go one way, you're going to bother someone. If you go another way, you're going to bother someone else. So I think you need to have legal advice in answering this question.
Great. Thank you, Ben. All right, next question. Sorry, just lost my spot here. And Heather, I see you have your hand up too. Wait, there was another question if I can get back there.
Oh, Audrey asked about
yeah, thank you. There we go.
The lead provision,
yeah.
and it's whether new means a second unit in an already single family dwelling, such as an ADU. I think the answer is yes. So you take an existing single family home and convert a portion of it to an accessory dwelling unit. You are adding a new residential unit. So that would require a lead safe certification.
Great. Okay, skipped. Changes to Senate Bill 78. This is from Ryan O'Connor. The changes to 7078 allow developers to construct roads without bonding, but can a municipality, and this, I think this question came up again, can a municipality hold final approval until completion of work or having bonding in place?
You know, I was thinking about this. Ryan typed this in, and you were doing your portion of the presentation. I was ruminating on this question. I think the practical answer is no, because you're not going to have infrastructure improvements commencing until you've got final approval. So I think the answer is no to this, that you can't withhold final approval until you have bonding in place. This law says you've got to allow the construction to begin, which means you already have to have your final approval in place before the construction begins. That construction of improvements can begin without bonding. It's what this law requires is that you can do bonding before the sales of property or the issuance of a building permit for structure for human occupancy.
Great, thank you, Ben. And then Liz clarified, thank you, that the House Bill 1641 applies to parking lots with more than 80 parking spaces. Thank you, Liz. Does the density for age restricted apply now? This is from, does the density for the age restricted incentives apply now to workforce? So if there's a density incentive, any density bonus for age restricted housing, yes, that now applies to workforce housing. Does OPD, this is from Eric, does OPD incorporate legislative changes into planning and zoning board training? Yes, as I said, we'll be issuing our annual planning and zoning board, our planning and zoning board handbooks early next year, which will incorporate the legislative changes. So yes, that happens every year. Last year, we also did a separate planning and board and zoning board handbook update. I'm not sure we'll do that again next year just because we did just do this webinar, which would cover many of those same changes. That's to be determined.
No, there's somebody who had their hand up. Do you want to take that question?
Sure.
Right,
great.
Janet, I allowed your mic so you can unmute yourself and ask the question. You would need to unmute yourself, Janet. I'm not sure what's going on there.
Okay, Janet, you should have if you're still here, you should have the ability to unmute yourself. Your mic is enabled. We are able to, Lila, and others, we're able to individually unmute folks. Okay, well, she is figuring that out. We have a question.
If you raise your hand, we will unmute you.
Yes. Does lead certification apply only to interior or to exterior as well?
Good question. I believe that it would apply to certainly to interior and to common spaces, and I think that would by extension include the accessible exterior spaces as well. But I'm not exactly sure on that last part. That's a good question for someone who does this for a living, this sort of certification work.
Okay.
We also have a point by John Bergeron regarding the fire code, and he says fire code uses NFPA. Yes, they certainly do. And the fire chief can't waive NFPA. I think the state fire marshal has the ability to do that, though. And NFPA requires a 20-foot wide fire lane. So that's for every driveway. This statute is in essence overruling, for New Hampshire's purposes, NFPA 1. So yes, the planning board, and my read of this is the planning board, it's not so much ignoring the advice of the fire chief, because it says you shall consider the advice of the fire chief, but it is advisory. And it specifically talks about driveways of 150 feet length or more being at least 12 feet wide, not 20 feet. So this is a statutory override of NFPA 1.
Got another message here. Okay.
That's from me, and I'm just trying to let Janet, you can unmute yourself. I'm not sure why.
Okay, can you hear me now?
We can.
Okay, my question is about a current subdivision in our area that's under development, primarily on a ledge without test wells to provide water supply information to potential buyers. Will this be affected by the new legislation?
Are you referring to the subdivision, the one that Ben talked to about subdivision regulations and water supply?
Yes.
Well, this is actually kind of along the lines of that healthy debate I talked about on the application of the driveway surety. We have in our Constitution a prohibition against retrospective legislation, things that apply to things that have happened in the past. You've got a subdivision that's been approved under construction. This new law would not apply to that.
Thank you.
I'm going to give it know we're almost over 10 minutes. So any last call before we bring this to a close? Okay. Anybody else want to raise their hand? Okay. Not seeing anybody. I think many of you know how to reach Ben and I already, but here's our contact information. Can't speak for Ben, but for me, feel free to email or call with any questions. As I said, we'll be doing another webinar in January. That invite will be going out very shortly, and we'll make sure that everybody that attended or registered for today gets an invite to the January 18th webinar. I want to wish everybody a safe, happy, and healthy holidays, and we'll see you in the new year. Thank you so much for joining us today.